Don't let your final farewell stir up family feuds. Welcome to Before You Go, a podcast brought to you by Texas Estate, Trust, and Guardianship Attorneys, Stacy Kelly and Keith Morris. Preserve your hard-earned legacy. Be in the know.
Hi, we're here again with Before You Go. I'm Keith Morris, and we're here with Stacy Kelly, and we are going to talk today about independent administrations in Texas. It is a sort of procedure that is somewhat unique to Texas, and so we're going to navigate through how that works exactly and what the reasons would be that you would file an independent administration, and the advantages and disadvantages. And so I'm going to turn it over to Stacy to talk to you about what it means and how it works.
Okay, independent administrations in Texas can happen in two ways. One, the decedent left a will and named someone to be executor to serve independently and without bond. Or if they don't leave a will, all of the heirs at law can decide among themselves to appoint someone to be an independent administrator. So it's either by will or by agreement of all the beneficiaries. Independent administration basically means you have limited involvement with the probate court. You file the will or have a determination of heirship, someone gets appointed, file an inventory, and you are pretty much finished. There's a couple other filings, but you're finished with the probate court and you're allowed to proceed independently, sell things, distribute assets, administer the estate. Now, you can compare that with dependent administration, which is where a person is appointed administrator of the estate and they have to get input from the probate court for every action that they take, which this definitely slows down the process and creates extra work.
I said extra work creates extra fees.
Oh, absolutely. So that's a decision that needs to be made, early on, if you have the ability to go independent, or some of the reasons why you want to go dependent. And we'll get into those a little bit later.
Okay.
So, Keith, how do we proceed to file for an independent administration?
There are appropriate ways to file an independent administration in circumstances. As we mentioned before, it's in two varieties, one of which is the decedent died and they had a will, and the will provides that the executor should serve independently without bond. And those are important words that have to be in the will in order for the court to allow the executor to serve without bond. And any sort of variety of something like that usually suffices. A lot of times in the wills that we draft, it says without bond, but it can also say without court intervention or, without any further input from the court or something like that. That usually gets you there as far as the will goes. It's a little bit more complicated with the independent administration because unlike the will, it's going to require the agreement of all of the heirs for two things. One, they have to agree on an administrator to serve independently. And then two, they have to all agree that the administrator will serve. And another thing that's come up recently that is a big deal, especially when there's property involved in the estate, is that you need to make sure in the waivers and consents that the heirs sign that they also authorize the independent administrator to sell real property. That comes up quite a bit. I mean, have you seen that more recently where if you're trying to sell a piece of property, the title companies are very picky about that, right? We've started including that in our waivers and consents that get signed. So in order to be eligible for the independent administration, as I mentioned, everybody has to agree. You have to agree for the executor or the administrator to serve independently, and you'll get a waiver and consent from all the heirs. The way that you effectuate filing, in the case of a will, you file an application to probate the will, and then you deliver the original will to the court if you have it, or a copy if that's all that you have. In the case of an independent administration, you draft an application for independent administration and heirship. In Texas, some counties require that the application be all in one document, and some counties require that it be in two separate documents. And so it is usually a good idea to call the clerk's office and ask what they prefer, or actually call the court and ask them what they prefer. Because sometimes those, they don't know. But you file an application for independent administration and heirship, either combined or separately. And then you also have to file an application for the court to appoint an attorney ad litem. And we'll talk more about the role of that person. But those are the two things that you need to file in order to get the process started. So, as I mentioned earlier, there are some unique features, ad litems, things like that. Why don't you tell us about how that works? And I know people from other states, when they hear about that, they're like, what is that? Is it just some person that gets paid by the court, or what happens?
This can happen in a couple of situations. One, there's no will. So a decedent's estate is going to go as per the estates code. And in that situation, you have to do a judgment or file for a judgment declaring heirship, which proves up the heirs of the decedent based on the statutes. In those situations, the family says these are the heirs, and they have witnesses that will testify that these are the heirs. The court will appoint an attorney ad litem. Their role in this is to basically make sure that what has been applied for, that those are truly the heirs of the decedent.
I also had a hearing this morning with a will that did not properly dispose of all the assets, and so we had to do an independent administration or do an heirship in addition. In fact, that was actually right before we got on this morning. So and I've also the circumstances where the ad litem where I was serving as an ad litem, where the family swore up and down that this family member was deceased, and I found them, and turns out they were not deceased. And so, interestingly enough, it's just you never know. I mean, other states have procedures where they don't go into that level of depth in order to determine whether or not people are being truthful or not. So, on one hand, it's a little bit more obtrusive in Texas, but on the other hand, I feel like we're really belt and suspendering the situation so that we make sure that everybody who should be included gets included. So the differences between dependent and independent administration, as you and I both sort of touched on, independent, you have one hearing, it's up front, you do the heirship and the administration hearing at one time, and then you're done. There's no bond, there's no asking the court for permission to do anything. That's it. But then the dependent administration, which is more difficult, is talk a little bit about that.
Well, it's a lot more burdensome. Obviously, you have to post a bond for the estimated value of the estate. And then once the administrator files an inventory, that bond gets adjusted up or down. The dependent administrator has to ask the court for permission to sell things, has to have the court appoint an appraiser if you need appraisals of certain real property or personal property that needs an appraisal. I once inherited a business of tow trucks, and I was the administrator, and I had to have all these tow trucks appraised because they had different equipment. And then sometimes with dependent administrations, it's a good thing, because if you served independently, you have more chance of getting sued. So sometimes you want a court overseeing what you're doing. If there's a lot of animosity in the family or something like that, the orders from the probate court can protect you down the road.
Also, one of the features of the bond, they only bond on personal property, right? Not the court doesn't require, because although apparently to some commercials on television, it's a lot easier to steal real property than you might imagine. The court doesn't generally bond on real property, so it's cash and personal property assets, basically things that can disappear.
Another advantage of a dependent administration, if an estate has a great deal of debt, there's a creditor claim procedure in a dependent administration that it's more protective than it is in an independent administration. And you have to send notice to creditors. They have to file a claim for the debt that they say they are owed. And if they don't file that claim properly and in just the right form, the dependent administrator can deny the claim. And after 30 days, that's it's barred. You can't sue on that, no matter how much money it is.
Yeah. And, we've done that quite a few times. I don't remember the last time I paid a credit card in an estate. I'm not saying that to brag, but I'm saying just we effectively use, in fact, we've had cases where all the heirs did agree and we could have done an independent, but because the creditor claims procedure in the independent administration is a little bit murky. Some people believe that it's the same as the dependent administration, but some people believe it's not. And rather than having to get into that like esoteric argument about whether or not it applies, it's sometimes just better to go the dependent route and make sure you get creditor notices out as quickly as possible so that the time starts running. Because, have you ever seen a creditor for a credit card ever file their claim correctly, ever?
No, I haven't.
Not
Now,
one time.
some of them are getting better at it because they've been denied so many times. We had one with Harris County Hospital District, and decedent had died from a severe accident and was treated at Ben Taub. And so there was a large debt owed to them, and they failed to file the proper claim in the proper way, and that huge debt was barred. So
Yeah, I got in an estate, American Express. The decedent had a black card and had about $75,000 or $80,000 on it, and we got it denied. And American Express blew their top and came in, and the judge was like, "Well, there's a procedure. Everything was sent out correctly. It's not really the administrators or any of the heirs' fault that you guys can't get your stuff done correctly." And the reason that claims procedure in Texas is so onerous. I know a lot about creditors because I used to work for some, but the reason the claims procedure is so onerous is because the fundamental purpose of the estates code is for the efficient and effective management of estates. And so there are other states that allow the claims procedure to go on forever and ever, but in Texas, they want, although it rarely happens this way, they want the family to be able to get in and out of probate court as fast as possible, right? So,
and the sooner you can determine the assets and determine the debts and get those paid, the sooner it can be distributed and closed.
Right. No, I agree with that. I can only think of a handful of times where we had the agreement of all the heirs, but because the estate was so debt heavy that we decided instead to file a dependent, that I've done that. Most of the time, yeah, we want everybody to serve independently because it just makes life easier. Having to go mother may I for everything, the court certainly prefers that cases be handled independently because that really kind of doesn't make them the bad guy. So it's sort of it's a good way to proceed.
What I always, if at all possible, yes, I think you should do an independent administration unless you have, a unique type of estate that it might be better to go the other way. Since most executors or independent administrators are not professional at their job, I highly suggest you work with a probate attorney to avoid expensive blunders or even a breach of fiduciary duty on your part. So I think it's good to serve independently if you can, but I would definitely recommend having a probate attorney guide you through that.
So I think we've had sort of gone through the ins and outs of the independent administration process, whether it be with a will or by doing the independent administration and the heirship. And we just thank everybody for listening today. Feel free to follow us. We're on Instagram and YouTube and all over the internet. And also people can submit questions by either emailing us or posting things on any of the social media where this stuff is distributed. So we thank you very much for today. And don't forget, before you go, there are things that you should know about independent administrations.
Now, before you go, learn more about how Stacy and Keith can help protect you by calling or visiting us on the web. Links to our website and phone number are in the show notes. The information on this podcast is for general information purposes only. Nothing on this podcast should be taken as legal advice for any individual case or situation. This information is not intended to create, and receipt, viewing, or listening does not constitute an attorney-client relationship.